As an influencer or content creator, you may come across an experience like I had earlier this week where a company will take your content and use it without your permission to market them and claim that you endorsed their company. Today, we're talking to everybody's favorite IP and entertainment lawyer, Tony, to find out what steps to take and what happened when he and I experienced this inside of my business just this week.
Hi, my name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and have an Instagram, YouTube, and TikTok account called the IP Professor that is dedicated to all things intellectual property.
Tony, I want to talk about something that happened this week that you were so incredibly helpful with. This week, I had my content stolen. So let me paint a picture for all of you. I had put a video on an app, and the company that I had been talking about their product saw this video, took the video, put it on Instagram, tagged me, then put it in their stories and said that I endorsed them, all without my permission. Now, I immediately went to Tony because he knows everything and he guided us through this process. So, Tony, what happens when people take your content and use it in a way that you did not get permission about?
Well, there's a lot of things to do, but I always say step number one is to always take a deep breath and relax, because I think that there's always a solution to everything. And I think, yes, tempers can flare and emotions can run very high in a situation like this, but it's always good to present yourself in a very cool, calm, and collected manner. So that's step number one. Step number two is to start taking screenshots and identify everything. Ironically, as soon as Cam had messaged me about it, I literally went to this brand's website and I took screenshots from their homepage that featured KM. I screenshots of the actual reel itself and her comment in the comment section where she says that they never was authorizing the use of this video, and obviously that would be all those screenshots would be paramount. And then essentially we didn't need to, because they eventually took down the post. But the next step at that point was to identify what we were going to argue in the cease and desist. So ironically, I was in the process of drafting it, but the main point that I wanted to stress was that at the end of the day, what KM created, what she shot herself, is her copyright. And we've talked about it before a bunch of times here in KM's videos. I'm sure you can check them in a playlist somewhere. But copyright is an original work of authorship fixed in a tangible medium of expression. Videos, like user-generated content, like what KM recorded, qualify as copyrighted works. And so when she creates a copyrighted work, or when anybody creates a copyrighted work, there are rights that immediately vest with that person. So in this case, in order for the brand to use KM's video, they would actually have to get her permission. And the permission basically allows them the ability to publicly display that video in some manner. By them just taking the video, uploading it on their social media platforms without KM's full consent, now what's happened is they violated her public display right under 17 USC 106, the Copyright Act's exclusive rights specific to public display rights. It's very clear, and there are 6 of them enumerated in the Copyright Act. So of course we could lay out that we can make an argument that there was copyright infringement because one of those rights were violated. We could also argue the whole essence of access and substantial similarity, which is imperative to a copyright infringement claim. But just important for everybody to know, we can make those arguments, but at the end of the day, if we even wanted to act on it or make some type of actual executed fashion or some type of action against the brand, we would have to take that video that KM created that is the subject of this infringement and register it in the U.S. Copyright Office. We can't claim copyright infringement and proceed with the claim without that video not only an application filed in the U.S. Copyright Office, but we need a full registration with an actual registration number. Usually that's about a 3-month process, maybe max 6 months, but it's a pretty quick process. So then once you have the registration number, then you can kind of commence the action. But then the one argument that I thought was a bit unique that I was going to put in the cease and desist, which is kind of a shame that it never happened. But anyway, the one argument I was going to make is that what KM, by using KM's likeness, her name, her image, and her likeness in the video, what the brand was doing was essentially violating her right of personality. And right of personality is a very under-discussed avenue of intellectual property law. It basically involves the use of one's name, image, and likeness for commercial use. That can involve somebody that is living or somebody that is dead. So the problem with right of personality, though, is that it's governed on a state-by-state level. It's the only area of intellectual property law that is not regulated at the federal level. So basically, we would have to check in terms of where KM is domiciled, what the rules are there. But the general notion across the board, the common law standard, is that if you're going to use somebody's name, image, and likeness without their permission for commercial use, that could constitute a violation of right of personality. So those were the core arguments that we were going to make. And I think that, essentially, if you're a content creator whose content has been infringed on, you have to ask yourself these questions. What copyrights were violated, and lay them out and explain what rights were violated specifically. Like, was it a public performance violation? Was it a public display right violation? Was it a violation of a derivative work right? What could it have been? Then identify if there was potentially a right of personality violation. If your face is visible in the video and a brand is using your video without your permission, does that qualify as a right of personality violation? Odds are yes. Bethany Frankel is literally in the middle of a massive lawsuit against TikTok on this exact point, very similar to what KM endured, where she posted a video about what she wears. She was going through I think it was like a get ready with me video that she posted on her TikTok. Sure enough, brand X took her video, uploaded it on TikTok as ads, sprawled it everywhere, and kind of multiplied. And it was to the point that Bethany Frankel pursued an action against TikTok, alleging that they didn't do a good job of policing this type of effort, and it was a clear violation of her name, image, and likeness. And then lastly, if your video that you create contains other IP elements that belong to you, like a trademark, then that's also something you have to consider if that could qualify as a trademark infringement matter. That if a brand, let's say, rips your video off from somewhere else that contains your trademark and then uploads it on their platform.
That makes a lot of sense. And thankfully, in my case, we didn't have to go too terribly far down the road of making them take things down. They did realize what they did was wrong, and they did take that video down. But I want to dig a little bit deeper. Let's say that hadn't happened, and we did have to take a couple more steps. With this, is this something that we should be doing on the platform where the violation took place, or should we go and get their email and do it through email? So in this specific example, they put the content on Instagram. Our conversations were done through Instagram. Is that the best place to be continuing this conversation had it not ended right then and there? Or should we move that over to email to make it more legally friendly?
Yeah, I would say email is the way to go. You want to formalize this process. And then not to mention, it's much easier to keep a paper trail via email than social media DMs. Yes, it's convenient, especially if, let's say, you don't have that brand's email address necessarily, but you're saving yourself a lot of headache if, let's say, you send a cease and desist through the DMs and then, God forbid, that DM disappears. So formalizing the process through an email, getting a red receipt to make sure that they got that email, that cease and desist, and just staying on top of it, that's going to be that's the name of the game here. And basically, it's the ball's in their court to respond and take appropriate action to responding to that cease and desist.
Now, as we continue down this path, let's say we've reached out, we've done our due diligence, we have emailed them, we have sent them all of the information, we've worked with a lawyer to make sure that everything is worded properly. You guys know the drill.
Stressing that big time.
It's the most important thing, because I know I can Google things, I can look things up, and I still wouldn't get it correct. That's why I came to you immediately. So make sure you're checking with a lawyer when you're doing this. But what other steps should we be taking? Is this a time and place where I should potentially be reaching out to the app that they stole the content off of to let them know that that company was doing that?
Yeah, you can obviously take an action by doing a DMCA takedown notice. Certain platforms have different rules about DMCA's takedown, so you can just review what this process is for that. Obviously, asserting proof of your copyright ownership is going to be very important when it comes to doing these DMCA takedowns. So I would assume that conversation is going to be straightforward. But I would say that if there was a situation, if you're in a situation where you're working with a brand that infringes on your copyright or any other IP that belongs to you, and you send them a cease and desist and they don't respond, set a timeline, set a deadline. Normally in the situation that we were handed with, I would have put a deadline of a response of at least 2 weeks. Maybe I would have been a bit friendly and even said 30 days. just to at least give them the time if they uploaded it on multiple social media platforms to respond, to take down and do their thing. But it's you have to set those realistic deadlines. And listen, you can be a nice guy and still be threatening. So I would have said something like, please respond within da 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 days, or else we will have to take further legal action. And then that's the point where you figure out like what could that further legal action be. In a case like this, because it's a social media video, that's very small in nature. We don't need to buy an index number in federal court. So this actually could have been a very good copyright claims board case if it ever rose to that level. But that's the kind of thing that I would highly, encourage people whose material has been infringed on with regard to user-generated content. Just setting those deadlines and just holding them to it. I think keeping it real and holding them accountable is what's going to help propel the process along to a steady resolution for you.
And I know this question is going to come up from our viewers. So let's say we end up in a situation like this, and we are going to be issuing that takedown notice. Do people who are the content creators have the rights to potentially invoice people for the use or the misuse of their content?
Absolutely. I've seen it way too many times, even in my day-to-day job, where if it was just like an honest mistake, we just sign a retroactive license agreement and we move it along. That's extremely commonplace, and I don't think that there's anything wrong with that whatsoever. If that's your business model, do it. And it's at that point, if basically the brand wants to comply, maybe you're willing to negotiate it. But if they're willing to pay and you expect to be paid, why not? I don't think that there's anything that should be holding you back at that point.
Fantastic. Any final thoughts on how to navigate the world of potentially having our content stolen and misused?
I just can't stress enough how, this is so prevalent. This happens all the time, every day, all day. And if you know that you're the type of person whose content is more likely than not going to be infringed on, I think this is a good, loud, calling card for all of you. Go be proactive. Register the copyrights to your copyrighted works. Protect it, because you're going to need that anyway if you're going to pursue a copyright infringement claim at the end of the day. But you just really need to be proactive in protecting your brand, policing it at every step of the way. And don't be afraid. Don't feel like you sending a cease and desist or something like that is you being confrontational. That's you enforcing your rights. That's no different than if, let's say, you were denied entry somewhere when you have full rights to do it, or you're just doing what is the lawful thing to do. So I would highly encourage anybody who has been the victim of some type of infringement to really take the cease and desist situation, the process, very, very seriously as a way to enforce those rights.
As you were saying that, I felt like it's a very good example. A cease and desist is not something that is going to be super confrontational. It is kind of the equivalent of when someone walks into your house saying, "You are not in my house, please step out of my house." Is that confrontational? Not really.
And well, what I was going to say is actually the cease and desist, if anything, actually directly to that point, is more of you being willing to extend an olive branch before you start escalating it to something else.
Taking it to court.
Actually, cease and desist are designed to be mitigation tactics. You don't just jump to the lawsuit right away. Yeah, there are people that do that, but cease and desist can be a very, very, very effective mitigation tool to get you the remedy that you're seeking. So I love cease and desist for that reason alone. And I would highly encourage people to take them equally seriously.
And we want to make sure that we're getting your questions on this answered. So if you are not sure on something, or if you have further questions or examples you want to pitch to us to talk about, go ahead and let us know down below. And as always, you can get further questions and answers from Tony on his social media. Tony, where can everybody reach out to you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And you can follow my new entertainment law podcast, End Scene, every Friday on Spotify, Apple, or wherever you listen to podcasts.
If you have further questions on this, go ahead and drop those down below. Tony is coming back for more episodes to keep us legally protected inside of the realm of entrepreneurial endeavors and influencer life. So we want to make sure we're getting your questions answered for you as well. And hit that subscribe and notification bell, because every single day we're dropping new content to help you navigate the world of social media so that you can make more money online, but spend less time doing it while you are growing your online business to the best of your abilities. We will see you in our upcoming episodes.